As part of your estate planning, we may be providing you with a will, which we could call a last will for simplicity's sake. This particular video is for a review of a will when you are not creating and utilizing a revocable living trust. If you are using a living trust as part of your estate planning, you're going to have a different version of a will called a pour over will that's going to be contained in a separate video here. So if you're using a trust, please click out of this video and instead go to the other video that's available. For purposes of a last will, when you are not using a trust, remember that the point of estate planning is that we're not going to go through probate. Our objective is to retitle our assets, to schedule all of those assets through beneficiary designations to transfer directly from us to the next people in line, to the beneficiaries, as soon as we pass away. All that they have to do once we're gone is activate those designations, which happens through essentially use of a death certificate. Now, remember that we want to have a will at all times, even if we avoid probates. The reason being, we don't know what's going to happen when we're gone. So a will is essentially our final instruction manual for how everything should happen, who is going to make that happen, and any particular rules or contingencies for how that's going to work. In an ideal outcome, when we pass, our assets will go to the next people. We will never use our wills. We will never go through probate. Everything just gets filed away in a drawer somewhere, and that's the end of the transaction. So for purposes of reviewing your will, I want you to keep in mind, this is not going to be the most valuable document that we use. If we avoid probate, we won't use this will at all. So we want to make sure that the data inside this will is accurate, but I don't want you to stress too much about the details, especially all of the legal and structural details, because if we properly structure your assets, then we don't need to worry about defaulting back to using this. Now, in your will, you're going to have a table of contents. I want you to start by looking at the table. There will be numerous sections highlighted. There will also be several sections that are not highlighted. You are welcome to review every single line of this document. At a minimum, I want you to skim through the sections that are highlighted, especially as it concerns people that are named, dates that are listed, etc. And then for anything else, I'm just going to explain to you section by section how this will works in quite a bit more detail than we do during the actual review meeting. So starting off at the very beginning of a will, it's going to be who am I and where do I live? If I've ever used any other legal names before, such as married and maiden names, I want to make sure that those are listed here too, just in case anything should ever surface in one of those prior names. Article 1, if you have any family, spouse, and children, we're going to itemize those people here. Who is my spouse? When were we married? Who are my children? Names, dates, etc. Additionally, if there are any stepchildren because of a blended family, in my will, I'm going to end up identifying that those children are perhaps my spouse's children, but I'm still going to include them here for purposes of how we're doing the inheritance. In Article 2, we're going to have a few different things that are happening. So number 1, 201. When I pass away, if we happen to have a house that we're living in together, meaning me and my spouse, I just want to make sure it's crystal clear my interests in that property go to my spouse. I want to make sure that they have unrestricted access and control and enjoyment of that property for the rest of their lives. 202, if we ever happen to create something called a specific gift outside of each other. Let's say, for example, I want to leave my car to my niece, or I want to leave my house, my rental property, let's say specifically to my sister, and then everything else goes to my other beneficiaries. Section 202 will itemize any of those specific gifts that we're intending to create. And then again, outside of this context, with our asset itself, we're going to use some beneficiary designations in order to be able to facilitate that. And then finally, 203 through 206, our personal possessions, what we call our tangible personal property. When we pass away, It's a lot of time and it's a lot of effort for people to have to go through our stuff and essentially figure out what to do with it. When we're doing planning, it's a great opportunity for us to sit down and start identifying any guidelines, any expectations, any wishes for what might happen with our possessions. So, as part of your estate planning, one of the documents that we're going to provide you is called a personal property memorandum. It is quite literally a document, it's a Word file document with just a series of blank lines. And within that document, I can identify specific items like my family heirloom, my sofa, my collector's edition of blank. And I can identify groups of items as well. So I could say instead, you know what, just all of my furniture or all of my books. And I can designate what happens to it. So there's two things that I generally recommend people are going to think about here. Number one, what are things I have that are important? What maybe is an important family heirloom that I want to go back to my family, to a specific family member, or be held for kids or something like that? Or maybe I don't really care about what happens with it, but I need people to know that I own something valuable. Maybe I have a $10,000 piece of artwork. I don't really care what you do with it, but I need you to understand that that exists so you don't end up accidentally donating it or selling it at a garage sale. So the personal property memorandum, you can type in answers, you can handwrite answers. The document does not need to be notarized and it does not need to be witnessed. It is very simple, but I will always recommend number one, fill it out. Even if you only fill out a few lines, fill it out. And then if you end up doing that, I want you to give us a copy of it. And as you make changes in the future, just keep giving us the updated copies so we can supplement our files. For all of the things that are not important, the other side of this, I just want you to be thinking about general guidelines. So you don't have to go into a 50-page memo to itemize every single spoon and blanket in your house. But you should probably consider some general guidelines along the ideas of all of my books, donate them. All of my furniture, try to sell it. All of my collection of blank, give to Susie and she can decide what to do with it. So in your will here, it's identifying if I have made this memo, if I have written down in any capacity what to do with my possessions, that is my instruction. My executor, my personal representative, the people that are listed in this document, I'm giving you the power. You dispose of those items as I've said. However, in 204, it's entirely possible I just won't identify everything, or maybe I never made a memo to begin with. So again, executor, personal representative, I'm giving you the power. You make the decisions for me after I'm gone. And this all can be made outside the context of probate. 205, very importantly, what is personal property? What all falls under this category? The rule of thumb that I tell my clients, if I can touch it and I can move it, it's personal property. I can move vehicles. That falls under this category. I can't move my house though. So basically anything I can touch and move, I can include in this and then designate how to dispose of it. And then finally, 206, there are different costs that can come up in the process here, such as if we need to ship, my painting to my sister in Chicago. So to the extent that comes up, this is just providing how we're going to handle those costs. After this, Article 3 is generally going to be pretty simple. If you're married, most of the time, this is going to say, I'm giving everything to my spouse first. If you're not married or if you're not giving everything to your spouse first, then it's basically going to say, here's the plan for the next beneficiary. So in this case, what it's saying is I'm giving everything to spouse, but if my spouse is gone, everything is going to go then to my descendants. Descendants are defined back up here in Article 1. These are my descendants. And so when I'm gone, it's going to go to them in equal shares in a way that's called by representation. This is the English version of an old Latin term that we used to use called per stirpes. Basically, what it says is everything is going to continue down the family line. I'm leaving everything to you. If you are gone, it's going to drop down to your children, to my grandchildren. If I have multiple children and one of them passes away and didn't leave behind children, that's okay. What's left is going to be then distributed to my other children who survived equally. There is a possibility in any estate planning that all of my beneficiaries could be gone. There could be a very bad car accident, as an example. Statistically, this is always very unlikely, but in a term that you're going to see called remote contingent distribution in Article 4 here, we're going to itemize some amount of a backup plan. Sometimes that backup plan actually names people or charities and breaks out percentages. Other times the backup plan is a lot simpler, and it just basically says you're going to find my next of kin, the closest person to me in family relationship, and you're going to give them whatever's left over. It's not likely we'll get to this point of using this section, but we always want to have these backup plans just to be safe. Otherwise, the money goes to Colorado. Article 5, any people that are serving, we're going to itemize those people in the will. So the first is going to be the personal representative, the executor. If someone needs to be me after I am gone, here's who that's going to be. In this, we're usually going to use the same people that we listed in the financial power of attorney role, because they're really handling the same responsibilities, just at different points in time. And then 502, if I have children under the age of 18, then who would be guardian for them if I'm gone, if both of us are gone potentially, and we cannot provide that care. So for all the people that are going to be listed in documents, make sure that they're still the best people. If not, we can change them. And then make sure that names are in the correct order and that every name is spelled correctly. If there's a spelling error, just tell us again. We'll correct it throughout all the documents. Finally, 503, if there is a guardian that steps in, it's just important to understand there needs to be somebody who can manage your child's money. So if a guardian has to be appointed, we're saying that that same person would also become your child's money manager, their conservator. In Article 6, we're going to have a number of miscellaneous provisions. A lot of these you are welcome to read, but you don't have to. 601, most jurisdictions, meaning most states, have laws that allow judges to require an executor, a personal representative, actually to have to post a bond in order to be able to serve. Think about a bond for getting out of jail. It's kind of the same concept here. It's a bond because if the personal representative ran off and stole all the money, then there would be a way that everybody could be made whole from that action. Now, I'll tell you, bonds are very antiquated now. They're very, very, very seldom used. But we want to just be really clear in the will. Even if a state can impose a bond, we're not going to use a bond here. 602, there are different types of probate that happen after we pass away. So this is providing here, I want to use the simplest version of probate that is available. In Colorado, as an example, that's called informal probate. 603, whenever somebody is serving on our behalf as an executor or a trustee, if you end up having a trust in the future, they are entitled to ask for reasonable compensation for the time and effort that they spend carrying this out. Now, I will tell you, number one, compensation is optional. People do not have to ask for it. And a lot of the times with family members or close friends, people don't ask to be compensated. But this can take time and effort. And so if somebody wants to be compensated, they can ask for it. Second, compensation, the process is pretty heavily regulated by statute. So if somebody does choose to ask for compensation, please understand there are rules, there are procedures, and there's checks and balances. This is just really opening the door for them to be able to do that. And then typically from there, if somebody ends up stepping in and asking for the compensation, they're usually going to talk to somebody like an attorney or an accountant about how they go about doing that. 604, questions can come up after we're gone about how to treat certain things. It gets a little bit technical, but as an example, like retirement accounts, how do we determine what's the principal of the retirement account versus what's the income coming off of it? So we have a fairly detailed set of statutes here called the Principal and Income Act, and pretty much every state has this. And the idea is simply how do we define these very technical little pieces just to be clear about how taxes really are going to be handled. So this is giving a very detailed breakdown of that. And then it's also going to be referencing back to our statutes. 605 is a section I will highly encourage you not to read, but you are more than welcome to. There are circumstances that can come up when somebody is unable to inherit from us directly, when people are still minors, as an example, they may end up not being able to manage things because they're 10 years old. How do we structure inheritance then? How do we work with that 10-year-old for their inheritance? Or what if somebody is an adult and they're incapacitated? What if they're fully disabled? How do we then work with the people providing that care in order to be able to figure out what to do with this inheritance? So 605 is providing some direction about that. And then that is actually going to parlay us into 606. So these two sections are very, very technical. 606, to the extent that a person that I want to leave something to is in that disability situation. They may be looking to qualify or already qualify with needs-based assistance programs. Examples are things like Medicaid. I need the government essentially to step in and cover my nursing home bills. If I'm in that disability situation and somebody tries to leave me a bunch of money or a house or something like that, I have restrictions on what I can own and what I can receive in terms of things like income. What I get as inheritance is probably going to cause me to lose those benefits. And ultimately, it's going to cause me a lot more harm than good. There is a way that we can simultaneously take somebody's inheritance and allow somebody to access it while also receiving their disability benefits. And that's through something we create called a special needs trust. So 606 is providing in substantial detail all of the technical rules and basically processes for how that plays out. If this situation never comes up, if there's never a disability or special needs situation, then we're never going to use any of this. But we do want to have that language in here just in case. So again, 605 and 6, I'll encourage you not to read because it's so highly technical. But if you read it, then this will give you an understanding of how it works. 607, this just kind of flows from this. To the extent a trust has to be established because of this will, there is a maximum amount of time that trust can exist. This is called a rule against perpetuities. It's a very convoluted and complicated topic, but this is just saying the longest amount of time in which the trust can exist. Colorado has a particular law about this that allows trust to go for 90 years, just as an example. 608, if my heir, if my beneficiary can't manage things or receive things, then the executor, the personal representative who's carrying this out, they're going to be able to work with the person's power of attorney or guardian or whoever that's going to be in order to be able to facilitate getting that inheritance over and protect it. 609, ancillary administration. There are circumstances where people may own property in multiple states. So in that, the unfortunate consequence can be that if I have to go through probate here, but I also have a farm back in Illinois, then when I die, if I hadn't taken the steps to avoid probate, unfortunately, we're going to have to go through probate here, and then we're going to have to go through probate back in Illinois separately. That's called ancillary administration. And so this is providing that our personal representative, has the ability to do that process if it's needed. 610, delegation of authority. Please understand that the people that are helping us carry these things out, like our powers of attorney, our personal representative, they're not going to know everything and they're not going to be able to do everything on their own because they're not a super person. So, as needed, they can bring in other people and delegate to them to be able to handle things. So, common examples would be somebody's likely to bring in, an accountant to help them with everything. The personal representative can actually legally transfer some of their power to other people to do things on their behalf. So the 6.10 is simply giving them that power. Article 7, the powers of our personal representative, the powers of our fiduciary. In just a few paragraphs, a little bit over a page and a half, this is simply going to identify all of the different things that they can do for us when they're wrapping up our affairs. And then in Article 8, we're just going to have a little bit of a breakdown of how to resolve our final finances. So like as an example, 801, my personal representative, they can take care of all of my debts. They can handle anything that needs to be handled. And that includes even like paying for burial and cremation and all of that. 802, apportionment is a term that applies to the estate tax, or we can call them death taxes. It's highly unlikely that most people will ever even come close to having an estate tax issue because since 2011, the lowest amount of money that anybody has been able to leave tax-free is $5 million per person, and you double that as spouses. As of these videos, that number is all the way up to $26 million for spouses, 13 million each. But if somebody did end up in a situation where they owe estate taxes, there is a concept that we have that's called apportionment as to how we're going to determine how each individual heir is going to contribute towards those estate taxes. So this is just kind of providing some explanation about estate taxes and about apportionment. Sections 8.03, 8.04, 8.05, these are addressing very specifically my final taxes. When I pass away, there are certain deductions, there are certain exemptions that get claimed in order to potentially lower any final taxes that I would owe. And so this is just making sure that those deductions are all protected and utilized if they apply to me. And then 8.06, as of 2011, we have a new law that came into effect that allows spouses to basically take the tax-free exemptions from their spouses when they pass. So I mentioned that $5 million and $10 million number. That's what this relates to. So if my spouse passes away and I want to make sure that I can leave even more money when I die, I can port their exemption over to me and I can stack it on top of my own. This is a strategy that's really important to always consider doing so that we can leave the maximum amount of tax-free money to our family whenever we pass away. 8.07, if I choose to leave any charitable gifts after I'm gone, essentially, how are we going to do that? Our first choice is that we want to make the gifts from a source of income because we want to then reduce those income taxes by giving the money to a charity. That makes sense. So this is basically telling your personal representative how you want that to be done. Finally, Article 9, if you have any particular instructions regarding concepts of burial or cremation, we might include those in the will. It would be very, very short and kind of generic for you. I will encourage you, though, there is a document that we provide all of our clients called a Memorial Services Memorandum. It's only a few pages and it's a fillable digital document, or you can print it off. But it's going to give you the opportunity to provide much more detail between things like burial versus cremation. If I want any services to be held, have I already paid for any services? Or do I have any benefits that are going to cover those services? I highly encourage you all to complete that form, provide us a copy of it, and then at any point in the future, you can update it on your own. It doesn't need to be notarized or witnessed or anything special, but it's really important. We can't assume that our loved ones know all of this information. So let's take a few minutes, let's write it down, and I want you to get that back to us. And then finally, section 9.02 is a very lengthy definition section, so please reference it, followed by the most important legal provision called contest. In the context of estate planning, probate, wills, trusts, etc., we want to make sure that people can't fight. Fighting in this context, it is very complicated. It's very expensive. I had cases in the years and years that I did contested probate litigation. I had cases where my fees alone were $150,000, and there would be two, three, four other attorneys in the case. At the end of the day, it was the attorneys who inherited, not anybody else. So we can prevent that, but we have to do it in the document. So contest here is basically providing a penalty clause. If somebody that's going to inherit from you, or even somebody who wasn't going to inherit from you, comes in and they try to sue, they try to undo your plan. There's some different examples here, but if they take an action here that is against your plan, they will be stripped of any roles that they have, they'll be cast out, and they will lose every penny. This provision works fantastic. It is authorized by state laws, and it gets people to the table. If there is a dispute, there are ways people can go through it without triggering this, like going to mediation and having a third party help them settle. But if somebody finds out that they're about to get completely disinherited because they're going to file this lawsuit, it's going to stop them from filing the lawsuit. It's going to get them to the table. How can we resolve this, even if it's a begrudging resolution? At the end here, there's some legal provisions. So survivorship, it is possible, for example, if there's a couple, a married couple, it's possible they could both be in an accident. They could both pass away. So we don't want to have to go through the process of, if I pass away, then having to close out my whole estate and distribute all of my money and property to my spouse, only for them to die a week after me, because then we're going to have to do it all over again. So we just set kind of a time frame here. It's 30 days that if I pass away, if somebody passes away within that 30-day window, we don't have to bother trying to get them the inheritance. We'll just move it to the next place in line instead. Finally, 905, there are just some very basic general provisions. For example, that this will is being created under Colorado law, and then some very basics about essentially contracts here. So your will, it is very straightforward. It is just a bit dense. Again, the objective is that we're not going to use it, but we still want it to be clear. We want it to be accurate. And then, of course, we want you to understand what the will is and how it works for future awareness.